Kasi I have my job. I have my regular job. And I also have disengagement. So, but I try to do them all. Hindi naman ako nag-excuse sa inyo. If kaya ko, kaya ko. All persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. So Article 1489 speaks about persons who are authorized in this code to obligate themselves. Okay? When we talk about yung code na sinasabi niya dito, we talk about the civil code. Ang civil code, guys, ito, tingnan nyo Ito, Article 1489. Ang civil code, merong 2,000 plus articles. So, ang dami niyan. Okay? Lahat ng persons authorized dito sa civil code, lahat na mahanap nyo dyan sa 2,000 articles na yan, they may enter into a contract of sale. And one of that is yung sa age of majority. And those natural persons that have legal capacity, meaning they reach the age of majority, and those juridical or artificial persons. Kapag juridical or artificial persons, we're talking about corporations, partnerships that has its legal existence, or meaning they exist in compliance with the existing laws, okay, that have their legal existence. Yan yung mga allowed the persons to enter into a contract of sale. The second paragraph, where necessaries, okay, where necessaries are those sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price therefore. Necessaries are those referred in Article 290. When we talk about necessaries, these are things or properties that are essential for the survival or existence of a person. Meaning, food, clothes, okay, yung importante in their schooling, okay, lahat yan. Lahat yan, they are considered as necessaries. Ang sabi ng second paragraph, kapag nagbenta ka ng necessaries sa minor, sa bata, other person without capacity to act, sa baliw, sa pipi o sa bingi, okay? Person who are deaf and mute. Okay? Ang sabi ng second paragraph, that is a valid sale. Okay, why? Because they are required to pay a reasonable price. To pay a reasonable price. Okay, that's why they're considered as valid. But this is the exception. The general rule is that a sale to a minor or to a person without capacity to act, okay, is generally voidable. Okay? A sale to a minor or to a person without capacity to act is voidable. Okay? Meaning, anong ibig sabihin ng voidable? If you can recall your obligations and contracts, ang voidable is a contract that is valid until annulled. Diba? A voidable contract is a contract that is valid a contract until annulled. Okay, meaning this contract can be ratified by kung minor yan by the guardian. Kung baliw yan, pwedeng yung guardian din. or by the person who has the authority or custody of the minor or the insane person. Okay? Ang exception, kapag ang binenta mo ay necessaries, valid yan. Okay? Kaya yan, nung bata kayo, bumibili kayo ng pagkain, ng damit, that's a valid sale. Okay? Kapag bumibili kayo, nag-shopping kayo, kasama ang magulang nyo, okay, silang nagbayad, that's a valid sale. Okay? Para maisip nyo, ma-example nyo. Okay? So, the general rule, all persons, I have discussed this na kanina, di ba? Whether natural or juridical, who can bind themselves, have legal capacity to enter in a contract of sale. Di ba? Yung natural, age of maturity, juridical, those that has its legal existence. Okay? When we talk about natural, syempre dapat yung wala din siyang incapacities. Yun yung exception. People who are incapacitated. Okay? How can we know if a person or a natural person is incapacitated? So, that is provided by Article 1490 and 1491, this one. Okay? But before we go there, we need to classify that there are two kinds of incapacities. We have the absolute and the relative incapacity. When we talk about absolute incapacity, okay, these are the persons that cannot enter into a contract of sale. Okay? This is the general rule. These are the minor, the demented or the insane, the deaf and mute. Ito yung example natin kanina. Yung sale dito is either voidable or unenforceable. Kung voidable, valid until annulled. Kung unenforceable, it's valid but you cannot enforce it. Okay? Because, let's say it's against the statute of frauds. That's why you cannot enforce it. Okay? That is an enforceable contract. Of course, the exception here is what we have read kanina, which is when the sale is, or when the sale are what we call necessaries. Okay? Yeah, necessaries. The second incapacity is relative incapacity. When we say relative incapacity, he cannot buy certain property. Okay? Yung absolute, hindi talaga makabili ng kahit anong property. Yung relative, pwede siyang makabili pero meron siyang mga properties na hindi pwedeng bilhin. Yan yung relative incapacity. Meron siyang capacity pero with regards to this property, hindi niya pwedeng bilhin. To that property, hindi niya pwedeng bilhin. Ganun. Okay? That we will discuss in 1490 and 91. The first relative incapacity is what we call is between the husband and the wife. Meaning, the husband cannot sell his property to the wife cannot sell her property to the husband. Why? That's absurd. First na impression mo, that is absurd. Yung asawa mo, bibenta sa yung lupa mo, asawa mo siya. Di ba? Para maintindihan nyo, before kayo ikasal, meron tayong tinatawag na marriage settlement. Okay? Before kayo ikasal. Usually, finifilapan nyo yan or nag-agree kayo dyan. Ang sikat na term dyan is what we call prenuptial agreement. Prenup. Okay? Yan. Diyan yung pag-uusapan kung ano ang property regime nyo. Sir, attorney, ano yung property regime? Meron tayong tatlong klase ng property regime. Okay? Ang isang klase ng property regime is what we call absolute community of property. Take note, absolute community of property. When we talk about absolute community of property, meaning all the properties that you have and those that you will acquire during the marriage belongs to both the husband and the wife. Lahat ng properties na ma-acquire nyo or na gusto nyong dalhin sa marriage will belong to both you and the wife. Okay? Yung next naman is conjugal partnership of gains. Conjugal partnership of gains. Okay? Meaning, lahat ng income at properties na ma-acquire nyo during marriage belongs to both of you. So there is a difference between absolute community and conjugal. Absolute community, yung mga gusto mong dalhin sa marriage na property mo at ma-acquire nyo during the marriage, yun yung sa inyong dalawa. Yung conjugal naman, lahat ng income at properties na ma-earn nyo lang during the marriage lang. Conjugal yan. 3, separation of property. When we talk about separation of property, yung kay husband ay kay husband lang. Yung kay wife ay kay wife lang. Di ba maganda? Okay, yan ang property regimes. Okay. Ngayon, most sa ating mga Pilipino or sa province, sabihin mo na lang siguro, wala silang ginagawang marriage settlement. Hindi sila nag-uusap about prenup kasi gaya nga ng notion na matanda na kapag prenup or prenuptial agreement, parang iniisip mo na, ay, property ang habol nito. Ay, yung kayamanan namin ang gusto nito. No. Okay, that is about settling your property regime. Okay, kasi kung hindi kayo nag-settle ng property regime nyo, ang nakalagay sa batas, kung wala kayong marriage settlement, ang magko-cover is absolute community of property. Meaning, lahat ng properties na dadalhin mo sa marriage, okay, at yung ma-acquire mo during the marriage shall belong to both of you. O, diba? Mas mabigat yun. Kasi lahat pag-aari nyo. Ngayon, going back to relative incapacity, bakit bawal magbenta si husband kay wife at si wife kay husband? Bakit bawal? Okay, in order to not prejudice creditors. Okay, scenario. Let's say for example, si husband, meron siyang utang kay sa kapitbahay niya worth 500,000 pesos. Meron siyang lupa worth 800,000 pesos. Okay? Wala na ngayon siyang pera and natakot siya na baka ipa-attach nung creditor niya yung lupa niya. So, ang ginawa ni husband, binenta niya. Binenta niya kay wife. Okay? Binenta niya kay wife. So, ngayon, si creditor, hindi niya na mahabol kasi yung lupa, nabenta niya na kay wife. Okay? So, okay lang yun kay husband kasi wife niya naman yun. Hindi niya naman busuin yun kasi mag-asawa naman sila. Kaya siya hindi allowed kasi it might prejudice creditors. If we allow that to happen, diba, the husband can just transfer properties to the other partner. The other partner can just transfer the properties to another. Okay? Kawawa yung mga creditors na naghahabol ng utang. That is the reason why we have this relative incapacity for husband and wife. Para hindi ma-prejudice yung creditors. The second relative incapacity is the guardian and the property of person under his guardianship or yung ward or yung mga insane na person. Okay? Bakit yan relative incapacity, attorney? Bakit naman yan pinagbabawal? Why? Because the guardian, okay, manages or administers the property of the persons under his guardianship. For example, ako guardian, okay? Tapos meron akong yung ward ko o yung bata na binabantayan ko is anak ng bilyonaryo na namatay at mag-isa lang siyang anak. Therefore, sa kanya lahat ng properties Lahat ng businesses, lahat ng corporations, lahat ng bank accounts sa kanya lahat. Sa bata. Pero bata pa siya. He cannot do that in his own. He cannot manage that. Ayan, kaya nandyan ako as guardian because I will be the one who shall manage and administer the properties habang minor pa si bata. Okay? Pag of age lang si bata, siya na. Okay? Ngayon, kaya siya bawal. Bawal bilhin ni guardian yung property ni ward or yung bata because it might uh, bore what we call abuse of your authority as a guardian because ikaw ang nag-manage, ikaw ang nag-administer. Paano kung binenta mo yan at a lower price pero sobrang mahal pala ng lupa na yan? Diba? You can take advantage kasi because you are the guardian, you administer the property, you take care of the property, you manage the business, pwedeng maabuso, pwedeng magkaroon ng bad faith on the part of the guardian. Okay? Next is agent. Agent and property under administration of sale has been entrusted. So agent and the property of the principal. Okay? The agent and the property of the principal. Ngayon, since their contract or their relationship is an agency, the agent only acts in behalf of the principal. Therefore, he cannot buy that property unless in his personal capacity unless in his personal capacity and with the consent of the principal. Okay? Because general rule, the agent is not a buyer, di ba? Sabi nga natin before. The agent is not bound to be the owner or to pay the properties because agent lang siya. But if binili yan ni agent, dapat merong consent ni principal. Kasi generally, bawal yung bilhin ni agent. Okay? Because it might, bakit, attorney? Kasi pwedeng magkaroon din dyan ng parang undue na advantage on the part of the agent. Okay? Kaya siya bawal. Mamaya, he can sell the price pala at a much higher rate than what the principal is asking. So, ang ginawa niya, siya na lang ang bumili para he can sell it at a higher rate. Okay? Kasi ang agent usually, meron lang sila yung standard rates na nakaset dun sa kanilang contracts. Okay? Sa kanilang contracts. Pero these contracts differ. Merong contracts na they set a percentage. Merong contracts naman na as long as you can sell this basta ang price ni principal is 100, kahit mabenta mo ng kahit anong price, basta 100 ang ibigay mo sa akin, okay lang. May ganun na contracts. It depends on the contracts. Okay? Number 4, executors and administrators and property of the estate under administration. Attorney, anong executor, administrator, anong estate? So, isa-isayin natin. Okay? Kapag namatay ang tao or bago mamatay ang tao, nag-execute siya ng tinatawag nating last will and testament, di ba? Doon niya ilalagay kung sinong magmamana ng ganito, kanino mapupunta ang sasakyan, yan, last will and testament. Okay? Dito sa last will and testament, ang tawag dyan sa law, testate succession. Testate succession. Okay? Under testate succession, okay, or sa last will and testament, nandun sa will kung sino ang magiging executor. Anong ibig sabihin ng executor, attorney? Siya yung mag-execute ng last will and testament. Ibig sabihin, siya yung magpapatawag sa mga heirs na naiwan. Okay, pinatawag ko ngayon kasi ganito, mayroong last will and testament, si ganito na namatay na, ito ang gusto niyang mangyari. Una, ganyan-ganyan. Okay, bibigay lahat ng properties. Ganun yung executor. Okay, Yung isang klase naman ng succession is kapag hindi nakagawa ng last will yung namatay. Ibig sabihin, namatay siya, wala siyang ginawang last will and testament. Ang tawag dyan, intestate succession. Okay, walang last will and testament. Dito naman, since walang last will, walang executor. So nag-a-assign ng court ng tinatawag nating administrator. Yan. Yan na yun. Same ang trabaho ni executor at ni administrator. Although sa administrator, i-determine niya kung ilan yung estate, okay, ilan yung heirs, kung sino yung may claim dun sa properties. Yun yung difference nila. Yung estate naman, ang estate, ito lahat yung properties nung namatay. Lahat ng properties ng namatay. Okay? From sasakyan, to lupa, to pera sa bangko, sa investments, mga shares sa corporation, sa partnership. Okay? Lahat yan, i-consolidate. Okay? Para ma-determine kung magkano yung paghahatian ng mga anak or mga naiwan niyang pamilya. Yan yung estate. Okay? I hope that's clear. The executor and the administrator cannot buy the property under their administration because of the same rule under dun sa guardian and property. They are the one who administers the property. They might exercise undue advantage over the property. Okay, then they can manipulate. There could arise conflict of interest, or they could sell the property to themselves, diba? At a very low price. Kaya bawal siyang ibenta. Okay? Public officers and employees and the property of the estate. Bakit? Precisely because you are the precisely because you are the government employees. Diba? State is the government, property of the government. How can the state act? Paano mag-act ang state and government? Siya imaginary lang siya. It acts through its public officers and employees. Kasi kung i-allow mo na bibilhin ng public officers and employees yung property ng state, baka wala ng property ang state. Diba? Operating on the same principle of what we have under guardian and property of persons. Because they can abuse their authority or their position if they are allowed to buy the property of the state. Kaya hindi yan pwede. The last one is justices, judges, prosecuting attorneys, clerk of superior and inferior courts, and other officers and employees connected with administration of justice and property and rights in litigation. Okay? Meaning, itong justices, judges, lahat yan, they cannot buy the property under their court. Kunwari, may hearing, or let's say for example, I have a case in RTC branch 1. Okay? And that case involves my property. Ngayon, yung judge dun sa RTC branch 1, gusto niyang bilhin yung property ko, ongoing yung case. Bawal yun. Okay? All properties and rights that are under litigation or yung ongoing yung hearing, okay, bawal nilang bilhin. Justices, judges, prosecuting attorneys, clerks of court, other officers and employees. This includes attorneys or private counsels. Okay? Private counsels or private attorneys. Basta, ang tatandaan nyo lang under number 6 is the property must be under litigation. If the property is not under litigation, okay, not under litigation, then pwede nilang bilhin. Pero if it is under litigation, hindi pwedeng bilhin. Okay, I hope that is clear. Article 1490. The husband and the wife cannot sell the property to each other. Of course, we have discussed this kanina. Except when a separation of property was agreed upon marriage settlements. Di ba? Sabi ko kanina, there are 3 types of property regime: absolute community of property, conjugal partnership of gains, and separation of property. Kapag separation of property kasi ang property regime nyo, yung kay husband lang, yung kay wife lang. Kanya-kanya kayo. Okay? Kaya yan, pwede kang magbenta ng property kay wife. Si wife naman pwedeng magbenta ng property sa iyo. Why? Because in the first place, your property regime is separation of property. Hindi absurd kapag binenta mo yung property mo sa wife mo. Kasi nga, yung sa kanya, yung sa akin. Okay? Unlike kapag absolute community property, yung sa akin, sa kanya. Tapos ibebenta ko sa kanya. Di ba? What am I trying to do? Di ba? I'm trying to defraud my creditors. Okay? The second one is where there has been a judicial separation of property. Okay? When there is a decree, okay, ordering the judicial separation of property of the husband and wife, pwede na silang magbenta sa isa't isa. So, general rule, hindi pwede magbenta si husband kay wife or si wife kay husband except separation of property or judicial separation of property. Okay? Take note, itong husband and wife cannot sell to each other applies also to common law relationships. What do I say when common law relationship? Mag-live-in. Common law relationships are those persons who are living together without the benefit of a marriage. They are living together without the benefit of a marriage. In other words, nagsasama sila na hindi sila kasal. Mag-live-in. Okay? Bawal din yun. Why? To not prejudice the creditors or to not defraud the creditors. Kasi let's say for example, ka-live-in mo. Ako, ang dami naghahabol sa akin. May ka-live-in ako. Ang dami naghahabol sa akin na pinagkautangan ko. Naubos lahat ng pera ko. Pero meron akong lupa sa Cagayan. Okay? Ngayon, nalaman ko na fa-filean na ako ng kaso. Ngayon, ang ginawa ko, binenta ko. Kanino? Sa ka-live-in ko. Para nandyan lang siya. Okay? Akin pa rin yung lupa, in essence. Okay? That is defrauding. That is in prejudice to the creditors. Okay? Niloloko or dinadamage mo yung creditors mo. Okay? Yun yung purpose nitong 1490. Ngayon, kung wala kang creditors, okay? Or wala ka namang tinatakbuhan, siguro. Okay lang siguro. Okay? Ang iniiwasan lang kasi is magkakaso later on. Okay? If, for example, binigyan mo ng, hindi, that is the reason. Although, this prohibition between husband and wife and between live-in partners applies also in donation. Meaning, the husband cannot donate to the wife or the ka-live-in cannot donate to the ka-live-in. Why? Because it might prejudice creditors or defraud creditors. Diba? Aside sa sale, o imbes na makuha nila yung lupa ko, i-donate ko na lang sa ka-live-in ko or sa wife ko. Diba? Para hindi nila makuha yung property ko. Which is not good. Diba? Kasi nagkautang ka, hindi mo binayaran, ngayon, hinahabol ka, yung property mo, binigay mo sa ka-live-in mo para hindi nila makuha or binenta mo para hindi nila makuha. Yun yung gustong protektahan ng batas. Kapag wala kang creditor, hindi mag-a-apply ito kasi wala namang affected. Yun lang, later on, kung meron naghabol sa'yo, okay, or meron ka palang pinagkautangan noon, kaya mo pala binenta, ayan, dyan ka hahabulin. Hindi pwede yan. Okay? Article 1492. The prohibitions in the two preceding articles are applicable to sales in legal redemption, compromises, and renunciations. So I'll give an example under legal redemption. Okay? Sales in the two preceding articles. So this is 1492. The two preceding articles is 1491 and 1490. Okay? So pili tayo dito ng kahit anong example. So let's say, for example, ito na lang yung justices and judges dun sa attorneys. Let's say, for example, this is the land of my client. Okay? Ito si A, siya yung client ko. This is my land. Eric, yan. This is my land. Okay? Ngayon, itong land ni client under litigation. Okay, under litigation. Ibig sabihin, merong case at naka-file na ako yung attorney niya. Ako yung attorney niya. Nire-represent ko siya. Okay? Ngayon, si A, dahil sa ongoing yung kaso, sabi niya gusto ko na lang ibenta para mawala na yung problema ko. So, binenta niya. In-offer niya for sale. Ngayon, since ako yung katabi niya na lupa, under the law, I can buy this property because I am the adjacent owner. Ibig sabihin, kasi katabi ko yung lupa eh. Who will benefit from that but me, di ba? Or yung isang may katabi na lupa. That's what we call legal redemption. Sales in legal redemption. I am redeeming that property as an adjacent owner. Katabi ko yung lupa eh. Di ba? Bawal din yan. Okay? Yan yung sinasabi ni Article 1492. Okay, I hope you understand that. Okay? Sana naintindihan yan. Effects of the contracts when the thing sold has been lost. Ito, this only contains 2 articles. Simple lang ito, no? If at the time the contract of sale is perfected, di ba? When is there a perfection of contract? When there is meeting of the minds, di ba? When there is consent. Okay? The thing which is the object of the contract has been entirely lost, na wala talaga. The contract shall be without any effect. So parang void contract. Example, I sold to Mr. A my house and lot. So I have 2 house and lot currently. Ibebenta ko yung house and lot ko sa Pampanga kay Mr. A. Okay? So, nag-usap kami ni Mr. A and then we agreed on the price, on the thing, and the manner of payment. We agreed. We came into a conclusion. Therefore, there is perfection. Okay? There is perfection. But, without knowing na habang nag-agree kami or hindi ko alam na nung nag-agree kami, nasunog pala yung house and lot ko. Okay, nawala. Entirely lost. Yung lupa hindi na ma-occupy kasi sobrang sunog. Kasi may garden yun, madaming trees. Nasunog lahat. Hindi ko alam. Pero na-perfect na yung sale namin ni A. Kinabukasan, pinuntahan namin yung Pampanga. Pumunta kami sa Pampanga. Nakita namin yung house and lot. Wala na. Sunog na sunog. Black. Burned to the ground. Even the land is severely damaged. Okay? Yun yung sinasabi nating the contract shall be without any effect because the thing has been entirely lost. Okay? Therefore, the sale is void. Okay? Second paragraph, but, sabi niya, but if the thing should have been lost in part. Kasi ang sabi sa first paragraph, if entirely lost. If it is in part, okay, only the vendee may choose between withdrawing from the contract or demanding the remaining part, paying its price in proportion to the total sum agreed upon. So, if dun sa example kanina, yung house totally burned to the ground, and binebenta is house and lot, okay, kung occupiable pa itong lot or pwede pang magamit, pwedeng ang desisyon ni buyer or ni Mr. A, pwede niyang mag-withdraw na siya. So, wala nang contract kasi void na nga. Okay? Or, bayaran niya yung lupa, which is the remaining part, but in proportion to the total sum agreed upon. Okay? In proportion to the total sum agreed upon. Okay? We say that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. That is when we say that the thing is lost. Yan, nasunog, cannot be found, missing, okay, pwedeng lost na yan. Okay, yung kanina, Article 1493, take note that at the time of the perfection of the contract, the thing which is the object of the contract has been lost, entirely lost. Dito sa 1494, specific goods naman. Okay? Where the parties purport a sale of specific goods and the goods without the knowledge of the seller have perished in part or have wholly or material or in a material part so deteriorated in quality as to be substantially changed in character, the buyer may, at his option, treat the sale as avoided or as valid in all that is existing or in all that can be bought. Meaning, parang partly siya. Okay? Ibig sabihin, itong specific goods, hindi thing specific goods. Okay? Specific goods ang subject natin, ang object natin dito, hindi thing. Okay? Let's say, for example, 100 sacks of rice. Okay? I have a warehouse where I have 100 sacks of rice. Ngayon, I and Mr. A agreed into a contract. I and A agreed into a sale wherein ibebenta ko lahat ng 100 sacks of rice ko kay Mr. A. We agreed not knowing na 50% nitong 100 sacks of rice is na damage because of the recent flood. Okay? What can the buyer do? Si Mr. A, meron siyang dalawang option. He can avoid the contract or rescind the contract. Itong avoided is rescind or cancel the contract. Okay? Hindi yan withdraw. The second one is to pay the price if the sale is divisible. Okay? Of course, you pay the proportionate price. Since 50% na lang ang pwede, 50% na lang nung total price ang babayaran mo. Okay? So take note the difference between 1493 and 1494. 1493 refers to things. Okay? Kapag partly loss yung thing, okay, the buyer can either withdraw or pay the price in proportion to the total sum of the price. Kung specific goods naman, si 1494. Meaning, the buyer can rescind the contract or pay the price in proportion to the total sum. Now, let's proceed to the last part of our topic, sale of real property in installment. Now, we have discussed about sale of personal property in installment. Na-discuss natin yan, no? Prelims, di ba? Installments. Sale of property, personal property installments. This is what we call the recto law. wherein the seller has three options, di ba? To exact fulfillment of the contract or the obligation, to rescind and to foreclose the sale, di ba? If you can recall from our prelim subject. Ngayon naman, we're talking about real property. When we talk about real property, immovable property, when we talk about immovable property, bahay, lupa, building, okay, lahat yan. This is the Maceda law. Okay? The Maceda law or the what we call Realty Installment Buyer Act is to protect buyers of real estate on installment payments against onerous and oppressive conditions. Meaning, there is a practice before that sellers take advantage of the position of the buyers. Okay, so masyadong dehado ang buyer sa sale ng real property in installment basis. Kaya nila ginawa ang Maceda law. Okay? Ngayon, dito sa sale ng real estate, okay, in installment basis, ang sabi ng law is where the buyer has paid at least 2 years of installments, the buyer has the following rights. The first one is to pay without additional interest the unpaid installments due within the total grace period earned by him. How do we compute the total grace period? When we talk about the total grace period, it is 1 month grace period for every 1 year installment paid. So dito, kasi ang sabi dito, kapag at least 2 years, ito ang pwede niyang magawa. So, kung at least 2 years ang nabayaran niya, therefore, ang nag-gain niya na monthly grace period is 2 months 2 months grace period because 2 years ang nabayaran niya in installment. Okay? So, within 2 years, pwede niyang bayaran yung due and demandable na installments niya without interest. Without interest. Okay? However, this right shall be exercised by the buyer only once in every 5 years of the life of the contract and its extensions. Meaning, if the contract is, let's say, for 20 years, okay, for the first year, siguro first to 5 years, okay, naka-incur ka on year 3, sabihin mo. First year, second year, nakabayad ka. Pero in the third year, hindi ka nakabayad ng installment. Under the law, you have 2 months grace period to pay without additional interest. But can only be exercised only once in every 5 years. So after 5 years, hindi ka pwedeng mag-exercise nitong right na ito na magbayad without additional interest. Kapag natapos ang 5 years, doon ka ulit pwedeng mag-exercise nung right. Yun yung sinasabi under letter A. Ngayon, paano kung, attorney, kung after the grace period ng 2 months, hindi pa rin siya nakabayad? Okay? Punta na tayo sa next. The contract will be canceled. But before the contract will be canceled, okay? Before na ma-cancel yan, the seller shall refund to the buyer the cash surrender value of the total payments made. Hindi yung cash surrender value ng property, yung cash surrender value ng total payments made. Ibig sabihin, if ang monthly installment niya is 10,000, so times, let's say for example, 2 years siyang hindi nakabayad, Yan, i-times nyo yan. Kung kayo na alam ng sagot na hindi ako magaling sa math, times 50%. Kasi yun yung cash surrender value. The cash surrender value is equal to 50% of total payments made. Total payments made. Okay. But after 5 years of installments, an additional 5% every year. So let's say for example, after 5 years, on the 6th year, meron pa siyang plus 5%. On the 7th year, meron siyang plus 5%. Okay? Idadagdag tong 5% dito sa 50%, but it must not exceed 90%. Okay? Ibig sabihin, it can reach 90%, but it must not exceed 90%. So, hindi na pwede ang 91. Kung 90, pwede pa. Okay? That the actual cancellation shall take place only after notice of cancellation or demand for rescission and full payment of the cash surrender value. Diba? So, all in all, ayusin natin. Kapag nakabayad ka ng 2 years installments, ito ang pwede mong magawa. Pwede kang magbayad without additional interest for the grace period na na-earn mo. Kung 2 years lang nabayaran mo, 2 months grace period, pwede kang magbayad without additional interest. Okay? Kapag hindi ka nakabayad within 2 months, pwedeng makancel yung contract. Okay? But before makancel yung contract, okay, kailangan meron mo ng, ito, number 1, notice of cancellation or demand for rescission. Importante yan. Number 2, kailangan mabayaran ng buo yung cash surrender value of the total payments made. Meaning, itong cash surrender value is equal to 50% of the total payments made. Okay? Yun yung if 2 years ang nabayaran mo. What this includes, sa lahat ng computations, kasama ang down payment, ang deposit, ang options. Okay? Kasama yan sa pag-compute ng installment na payments na nabayaran. Kung malaki yung down mo, of course, i-consider yan as installment. Depende kung magkano yung installment na payments mo. Okay, what if hindi umabot ng 2 years yung installment na nabayaran mo? Let's say, for example, 1 year and 9 months or 1 year lang or 1 year and 6 months. Okay? The seller shall have a monthly grace period of not less than 60 days. Not less than 60 days. Okay? So, hindi bababa ng 60 days ang grace period. Pwedeng 60, okay? Pwedeng 61, basta not less than 60 days ang monthly grace period mo. Ano to monthly grace period, attorney? Pwede kang magbayad. Okay? Within the grace period. Kapag hindi ka nakabayad, same dun sa kanina, makakancel. Sabi dito, if the buyer fails to pay the installments due at the expiration of the grace period, the seller may cancel the contract after 30 days from receipt by the buyer of the notice of cancellation or the demand for rescission of the contract by a notarial act. Ibig sabihin, okay, kapag hindi ka nakabayad doon sa grace period mo, okay, makakancel yung contract mo through a notice of cancellation or demand for rescission. Take note, the difference between Section 3 and Section 4. Yung Section 3, kapag hindi ka nakabayad, makakancel. Same. Pero, kailangan ng notice of cancellation or demand for rescission, same. Pero, meron pang babayaran na cash surrender value which is equivalent to 50% of the total payments made. Okay? Pero sa Section 4, notice of cancellation and demand for rescission lang. Walang payment of cash surrender value. Okay? I hope that's clear. The buyer shall have the right to sell his rights or assign the same to another person or to reinstate the contract by updating the account during the grace period and before the actual cancellation of the contract, of course. The buyer can sell his rights precisely because that right belongs to him. Okay? And he can assign it to another person or he can update the account or he can pay it. Ito na. The buyer shall have the right to pay in advance any installment. Paano kung meron siyang extra money, pwede niyang bayaran in advance? Yes, pwede. Pwede ba niyang bayaran yung in full, yung unpaid balance niya? Let's say, for example, nanalo siya sa loto, bayaran niya na lahat ng utang niya na hindi pa nabayaran? Yes, pwede. Unpaid balance of the purchase price. Full unpaid balance of the purchase price. This must be without interest. Okay? And to have such full payment of the purchase price annotated in the certificate of title. Okay? Kasi nga, ito ay sale of real property, di ba? Ang sinasabi niya dito na ma-annotate in the certificate of title, ang real property, evidence yan by what we call a certificate of title. Whether transfer certificate of title or original certificate of title. May title yan. Okay? Kapag yan, naka-financing or binili mo installment, ang usually naghahawak ng titulo is yung pinag-utangan mo or yung nag-finance sa'yo. Okay? Ngayon, kung nakabayad ka na in full, pwede mo yung ipa-annotate sa ROD, sa Registry of Deeds. Okay? Para ma-reflect dun na nabayaran mo na buo yung utang mo at para matanggal na nila sa titulo yung utang mo. Kasi nakalagay dyan sa property na yung property na yan is nakasangla o yung property na yan is naka-finance na mayroon pang utang, ganun. Okay? I hope that's clear. That is the Maceda law. Of course, any stipulation contrary to the previous provisions shall be null and void. Okay? So kahit pa yung contract nyo is contrary to all what we've discussed in section 3, 4, 5, 6, they are null and void. Ang masusunod is the Maceda law. Okay? So that ends our topic. Nag-exceed tayo ng konti, pero I hope that's okay. I'll see you next time. Please, nag-end na ba yung case studies nyo? I'll check if nakapag-submit na kayo ng case studies, okay? So mag-end na, I think mamaya, 12 yung case studies nyo. So please answer them now kung kaya. Okay? Thank you guys. Good night. Good night everyone.
Okay, sir. Thank you po.
Thank you, sir. Bye, sir. Thank you.
Sir, sorry po ulit kanina. Thank you po, sir. Sorry po ulit.
Sige. No worries.